Welcome to NASP's Dialogues. The Dialogue podcasts focus on events and issues in school psychology. I'm Rebecca Comizio, Chair of NASP's Communications Committee and moderator of our current dialogue. Today we are discussing IDEA dispute resolution and how to be a witness with Carl Corbin. Welcome.
Thank you.
Before we get into the specifics of special education law, what are some general sources of law that provide guidance regarding special education students?
Sure, there's as you mentioned, the Individuals with Disabilities Education Act. And so that is the floor for all the law associated with special education students. And that's interpreted by the United States Department of Education when they develop regulations. For example, manifestation determinations is at Title 34 of the Code of Federal Regulations, Section 300.530. So anything you want to know about manifestation determinations, that's where you would go to. Then there's also executive agencies that interpret and provide non-regulatory guidance regarding the law. There's three main agencies. That's the United States Department of Education Office for Civil Rights, OCR. Then there is the Office of Special Education and Rehabilitative Services, OSERS, and then the Office of Special Education Programs, OSEP. In addition to that, as I mentioned, that provides a floor of the law across the United States. But each individual state could pass additional law, adding additional clarification or protections. For example, while not required under federal law, under the Family Educational Rights Privacy Act, FERPA, there is, in California, the right, if a parent makes an oral written request, district has to provide a copy of a student's educational records within 5 business days. Parents also have the right with 24 hours notice to audio record an IEP meeting, an individualized education program meeting, even with, if the district doesn't want that, the parent still has that right. So again, I'm talking here all about federal law and the general rules associated with that. You do please look at your local state law because there may be additional protections or clarifications.
IDEA grants children with disabilities the right to receive a free, appropriate public education. What is a FAPE?
A FAPE, free appropriate public education. Excellent. So it's not actually clearly defined in any of the statute or regulations. So we had a case back in Board of Education of Hendrick Hudson Central School District versus Raleigh. Many people know about the Raleigh decision. That was the United States Supreme Court decision way back in 1982. And basically that talked about how do you know if the school district has provided FAPE or not? And they look at, has a district complied procedurally with the rules in the IDEA? So developing an IEP every year, doing your assessment within the particular timelines, all of the procedural requirements. So that was the first part. And the second part of the test is the substantive. And that was the IEP, was it developed such that it would be reasonably calculated to enable the child to receive educational benefit. The problem is there's been no definition of educational benefit, and so since 1982, all of school districts and courts across the United States were struggling about educational benefit. Does that mean 1 year's growth in 1 year time academically? Does that mean 6 months, 9 months? There's been no clarity on that issue. They talked about a minimum floor of opportunity, and you used to hear under Raleigh, you're entitled to the Chevy, not the Cadillac. I think that's been updated for the new century. You're entitled to a Prius, not a Tesla. But the Supreme Court did relook at this issue in 2017 in a case called Andrew F. versus Douglas County School District. And so Raleigh is still good case law. So the Andrew case did not overrule Raleigh, it just clarified what Raleigh meant. And so now the new standard across the entire United States is, in order to meet its substantive obligation under the IDEA, a school must offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. So for a student with significant cognitive limitations, we would not expect a year-for-year growth. But where a student is 100 IQ, specific learning disability, the Supreme Court would anticipate that student should be close to a year for year growth. So that is now the legal standard. And so unfortunately, there was 3 items in there that still have to be defined by the lower courts. And those 3 items were the IEP reasonably calculated for the student to make progress appropriate in light of the child's circumstances. And the good news is for attorneys, we're going to have lots and lots of case law on this issue until, and for those of you who listen to this podcast, I would encourage you to talk to your local representatives, your senators and representatives, because the IDEA has not been renewed since 2004. They were talking about RTI. MTSS was not mentioned. That's under the Diagnostic Statistical Manual, 5th edition. We have autism spectrum disorder. The IDEA still refers to autism using the old DSM-4 TR. So talk to your representatives. Let's get the IDEA repassed again, and hopefully that will help clarify some of these issues.
You've explained some of the implications of the most recent U.S. Supreme Court decision, Andrew versus Douglas County School District. What are some of the differences between a special education state complaint as compared to a special education due process hearing?
Sure. The difference between a state complaint, there's some significant differences. The first is both a state complaint and a due process hearing can allege complaints associated with the IDEA. But a state complaint can be filed by an organization or an individual. So an outside agency can come in and file a complaint, whereas a due process hearing, a due process complaint, only a parent or a public agency can file the complaint. An outside advocacy organization cannot. Generally, a due process complaint has a 2-year statute of limitations, meaning you can go back 2 years in time alleging concerns. And again, your state law may allow for a different time period, but that's under federal law. Whereas a state complaint typically will only allow going back 1 year in time. Some of the other differences is a state complaint. It's not a hearing in that, so a district or a parent makes a complaint, it's addressed and they ask information, they'll follow up with the parent, the state agency, they'll follow up with the district, and then they make a decision. Often these decisions can be quite inexplicable, and the decisions are not required to be made by any particular individual with any specific level of training. So often in my experience, it's made by educational bureaucrats, unfortunately, who are not school psychologists, not attorneys, not teachers. Whereas due process hearing, there's very specific requirements. It has to be heard by an impartial hearing officer with various required qualifications. Usually they're an attorney. The hearings a due process hearing allows for the parent or the district can have an attorney. They can call witnesses. They can have evidence. And again, for a state complaint, it is more opaque as far as the decision-making process. Generally, attorneys' fees are not awarded for state complaints, but parents, if they're the prevailing party with a due process hearing, depending upon the degree of success, they can have their attorney's fees paid for. So those are the main differences between due process complaints and state complaints.
How is a resolution meeting different from mediation?
And then first, for those of you, again, I apologize, listening to this podcast. It's a lot of information, but hopefully this is helpful. So then circling back around to resolution sessions. So where a parent files a due process hearing against the district, then the district has 30 days to convene a resolution session, a meeting. And during this resolution meeting, it's not an IEP meeting per se, in that you don't have to have all the required IEP team members there. The parent gets to select who they want to attend. The district gets to select who they'd like to attend this meeting. This resolution meeting is not confidential, in that anything that is shared at the meeting can be used in a later due process hearing or legal matter. That is why my office has developed, and in the workshop I've been presenting, and if anybody's listening to this podcast and they would like, I have a model confidentiality agreement that if the parties, the parents and the educational representatives, volunteer, that is, agree to keep everything confidential at a resolution session, they can do so and have a model document on that issue. Second big difference is if there is an agreement reached at the resolution meeting, then, and even in right there, the parent and the district representative sign off on that, and they say, yes, we're going to resolve this matter, they sign off. There's basically a 72-hour opportunity for either side to come back and say, you know what, even though we signed this legally binding document, we've changed our mind. Last thing with the resolution session is, and we have a letter from OSEP on this, and it's a letter to EIG, letter to IG, that stated basically parents can be required to go to the due process meeting, and if they don't come, they can't proceed to a due process hearing, but they don't have to, literally do not have to say anything, so their attorney can instruct them to not say a word, and then they're allowed to go to a hearing. The purpose under the 2004 IDEA of having the resolution meeting was to reduce the litigation cost, but in my experience, I have not seen that occur. The last thing to know about a resolution meeting is the district cannot have an attorney there unless the parent has an attorney. So that's the resolution meeting, or sometimes referred to as a resolution session, versus the mediation. For mediation, there is a mediator that will be provided through the state, and it varies from state to state, but that'll be a neutral person not associated with the parent or the district. Everything that is said in a mediation is confidential and cannot be shared in a later due process hearing. And attorneys can be present for the district and for the parent. Even if the parent doesn't have an attorney present, the district could choose to have an attorney there. And any agreements reached at the mediation session are immediately legally binding. There's not that 72-hour hold. The difference between, a legal difference between the resolution meeting and the mediation is where a parent files a request for hearing against the district, there has to be a resolution meeting within 30 days unless both the district and the parent mutually agree to waive that meeting. If the district files for hearing, there is no resolution session required because presumably the district has tried to work this out with the parent. Mediation is voluntary, and a parent or a district could choose not to engage in the mediation process, which is unfortunate. And again, in my experience out in California, and we in California, between California, New York, and Texas, we have those states have the majority of due process hearings in the United States. And so, for example, during the 2018-2019 school year in California, there was over 5,000 requests for a due process hearing. Over 95% of those settle in either a resolution session or, much more likely, in mediation.
What are your recommendations on how to be a witness in a due process hearing?
The first thing to recognize is I'm not aware of anybody who went to school psychology school just to be a witness at a due process hearing. I understand this can be a stressful event, but it does give you a chance to demonstrate your expertise in a hearing. I'd like to remind all of my colleagues that you are, in fact, experts. And whenever I call any educational representative, particularly school psychologist, I will have you designated as an expert because you are an expert in your respective area. So again, I haven't had anybody pass out on me or otherwise die associated with being called as a witness. I have had some crying, but everybody's made it through and they've done a good job. So the first step is take a deep breath. Second is to gather all of your records and information, which could include email and your personal notes, and then share that information with either your local educational agency representative or, if your district's represented by an attorney, with the attorney, because their job is to go and look at all of the information available, all of the documentary evidence, and then decide of all the universe of potential documents, what documents will be placed into evidence at a hearing. Because for a due process hearing, All the documents that the district or the parent wants to have used as evidence have to be provided at least 5 business days prior to the hearing. So you should know, and your attorney or your district administrator should be able to tell you, here is a copy of all of the documents that we've submitted, and then here's a copy of all the documents that the parents have submitted. And from there, imagine this is like an open book test. You're going to have the IEPs, you're going to have your psych report, you're going to have that information there at the witness stand. So please imagine this is like an open book test. Don't try to memorize everything. I have had, and one case in particular, where a witness for the district literally tried to memorize everything. And she was unable to. It frustrated her, and she ended up crying on the witness stand, and we had to take a break. And that's not good for everybody. We sat down. It was towards the end of the day, talked with her, explained more. Again, this about being an open book test. The next day, she was much more relaxed. She was able to refer to the documents and came across as much more polished and smooth. So first step, gather all your documents and information to include emails and personal notes. Share that with your attorney. From there, your attorney should be able to provide you the documents that will be discussed in the due process hearing and the parents' documents. Ask your attorney, what questions will I be asked? Your attorney should be able to provide you with not an actual list of questions, then with a very detailed understanding of what your role at the hearing is, what you're going to be asked about. Again, may not be able to predict the questions from the other side, but the attorney for the district should be able to have a good idea about what questions the parents will be asking. Then once you're at the due process hearing, keep in mind, again, this is your school district name versus the student. It's not a case against you, the school psychologist. You have no personal liability in these cases, due process cases, unless, and again, under state law, you generally will be sworn in as a witness that is swear to tell the truth and nothing but the truth, that sort of thing. So the only way you can really get yourself in trouble is if you perjure yourself, if you lie. Don't lie. Beyond that, it's your job to provide information to the hearing officer. So I found it helps the school psychologist that I prepare for witness is don't even look at the attorney, or if it's an unrepresented parent, when they ask the questions, don't even look at them. Look at the hearing officer, because if I'm asking questions of a witness, I believe you already. That's why you're there. The parent doesn't believe you. That's why you're in hearing. You want to direct your energy to the fact finder and decision maker, and that's the hearing officer. So all your nonverbal and verbal communication should be directed towards the hearing officer. Answering questions, if you're asked a question and you don't understand the question, then tell the hearing officer you don't understand, and the hearing officer will have it clarified. Documents. If you're being asked a question about page 37 of your report, then ask the hearing officer to be turned to page 37 of your report. It's absolutely okay to qualify your answers. What I mean by that is, if you're asked, and this would happen at the very beginning, how many assessments have you completed? You don't have to know that it's 5,321. You can say, I've completed over 1,000 assessments, approximately 1,000 assessments. All of that qualifying language is perfectly fine. The other thing is, if your attorney or the other side asks you a yes-no question, give a yes-no answer. If your attorney needs additional information, your attorney will ask another question. Anything that you share opens the door and does two things. One, it keeps you on that witness stand longer, and then two, it opens doors that the other side can now cross-examine you on. So even if you're asked an open-ended question, give a concise response, err on the side of brevity. We are school psychologists, and we love to talk. This is not the time. This is not the time. Again, if the attorney needs, your attorney needs additional information, they'll ask you another question. That's their job. Two additional items on this about questions is typically And your attorney should be able to tell you, is she going to be asking you questions first, or will the parent's attorney be asking you questions first? Let's say it's your attorney asking questions first. She asks questions, then the parent's attorney gets a chance to ask questions, then it cross-examination, and then it goes back to your attorney for redirection, and it's like a volleyball match. It goes back and forth until all the questions are asked. Sometimes, but not always, the hearing officer might jump in and ask a question. And then, is there anything else that I wanted about adding to be a witness? No, I think that's plenty.
Well, it's certainly a lot to think about and how to be an effective witness at a due process hearing. Thank you so much for joining us today, Carl Corbin. This concludes this Dialogues podcast. Please tune in again for future Dialogue podcasts available on the NASP website.